morning. First of all, I would like to thank Freedom House and the National Institute for of Magistracy for having invited me for the second time to speak in front of such a distinguished audience. It's not always common for a lawyer to speak for a training of judges, so this is really an honor to me. Going to my presentation. Going to my presentation, I want to get back to the title of the whole training, which is interdisciplinary approach in competition law between economy, legislation, and competition. So it's evident to all of you that competition law is at a crossroads between law and economy, or some kind of economy. So my idea is to provide you in this opening conference general understanding of how the economic tools and analysis can fit into the legal analysis, into the decision-making analysis that you are confronted to when you deal with a case involving the application of competition law. But even before the introduction, I just want to confront you with a very simple example of a possible case. This is an oversimplification, and please don't make too much attention to the details. It's just to set the background of my presentation, to give you a first idea before even saying what I'm talking about, what I intend to do this morning. Imagine that a plaintiff, let's say a bakery, which sues milling companies for a cartel increasing the price of flour. Of course, the bakery has to make bread out of flour, and if the price of flour increases, it has to undergo additional costs. This is the same if the competition authority prosecutes these milling companies, or if a prosecutor implementing criminal law prosecutes them. And imagine also that the defenders, the cartel members, claim that the price increase is not due to the cartel, but to the increase in the price of cereals, because the milling companies, in order to produce flour, they have to buy cereal on the worldwide markets. So the evidence which is brought in front of the court, I repeat, this is really oversimplification, can look like this. Details are irrelevant. It's just to give you an idea of what you could find in front of you judging a competition case. So the plaintiff comes up with a kind of this kind of research, economic research. It is called interpolation analysis, but at the moment it's not important. Just you're confronted with this graph which says that the price of flour has increased due to the cartel, because there's a correlation. Because if you see during the period of the cartel, the price is strangely above the price, the increase of price you would have from before the cartel and after the cartel. Then the defendant comes and shows you with a statistical, and confronts you with a statistical analysis which say, no, actually, as you can see here, the price of flour is really strictly linked to the price of cereals. And at the time of the cartel, the price of cereals has increased. So as you can see from this, and the party will say, this is very clear, you see, there's a strict correlation between the two prices. Then you may engage an expert, or this can come into discussion, that says that a more developed economic model shows that actually both the cartel and the price of the raw material influenced the price of flour, and so the difference should be considered only. It's more limited, so you should only consider that part of the surcharge of the cartel is actually fault due to the cartel's member behavior. And you can have much more elements to be considered, but this is just to set the tone. So once you are confronted with such an evidence, such information, the first reaction of a judge could be like this. This is certainly the first reaction of me as a lawyer when I deal with these cases. I mean, you are confronted with all sorts of economic definitions, in particular, acronyms, tools, and your job is to bring things back to what is normal for a law decision. You have to understand. I mean, you know the law, juris novit curia, they say in Latin. You have to understand which are the facts, judging if the evidence is enough, and qualify these facts under the law and decide. And this doesn't change just because it's competition law and there's a bit of economics in that. So what I'm going to talk about in this presentation. As I said, I would just like to provide you an idea, which is of course my idea, of how the economics should be dealt in competition cases. We have economics at two levels. We have economics in the law, because the two main provisions in EU law dealing with cartels and abuse of dominant position, they have a lot of economic linked concepts which have to be understood. And also, in particular, the application of competition law has a lot of economics involved, as in the case I simply put on before in a provocative way. So how economics can fit into the decision-making analysis. Let's start from the law. I will not bother you with this. You know, in general and probably in very detailed terms, what competition law says. In particular, I'm referring here as the title of my presentation to cartels and abuse of dominant position, but I just provide you an overview of where these provisions are within the EU legal system. Okay, this is the overview of general EU competition law. We have the basic provisions that we call more specifically antitrust law, which is the provisions on anti-competitive agreements and abuse of dominant position. Then we have other provisions of concentration, state aid, and basically public monopolies, special and exclusive rights and services of general economic interest. Here, just to localize, we are speaking about cartels and abuse of dominant position, which are dealt with Articles 81, 101, and what was the previous number? 101 and 102 of the Treaty on the Functioning of the European Union. Article 81 established that all anti-competitive agreements are illegal in terms, and including the cartels. As you can see from a first glance, but you already know this article, there are a few economic concepts in this article. Is law which speaks a bit of the language of economics. And the same for article, and then the consequence, of course, is that all agreements are null and void, so the judge should take the consequences of this also in terms of contractual law, commercial law, but you have some derogations. So, and here you find even more economic background, because in order for an agreement not to fall under the provision, you have to make sure that it has a positive effect for the consumers. So this requires an even a more sophisticated economic analysis. And similarly, Article 102 for the abuse of dominant position, which includes a lot of concepts relating to what is a dominant position, which implies the definition of a relevant market, which is the market is, how you calculate the market power, and so on. But I will not bother you with this in detail. Now, how these two basic laws, let's say, are applied in practice, and in particular as it comes to their economic implications. Okay, basically, the law against cartels and abuse of dominant position, they're tackling two anti-competitive behaviors. There are multilateral practices, cartels, and unilateral practice. So on the one side, there are more companies getting together and making something negative for competition. And on the other side, there's one big company, which is bigger than the others, and can abuse this position. I recently read an article that I quote here, which in my opinion is not that interesting, but I found it funny, the fact that basically the author struggled to demonstrate that antitrust law is very simple. In fact, he says it's all combating two of the most innate proclivities in human nature, which are bullying, when you are bigger and you exploit this fact, and ganging up, when you get together with others to make damages. And basically, he says that all you need to know about antitrust law you have learned and experienced in the kindergarten, when you have a bigger kid who hits the others, and some small gang of kids which excludes or mistreats other kids. But to go back on more serious terms, we have both for cartels and abuse of dominant position two main of anti-competitive practice on as it comes to economic effects. We have the practices which brings to exploitation, so you get an immediate benefit. You get together with your competitors, instead of competing, you decide to raise price, and of course you earn more money illegally. Or you have other more subtle forms of damaging competition, like exclusionary practice, like foreclosing markets to competitors. For instance, a dominant operator it's engaging in predatory pricing practice. What does it mean? That he puts the prices below the costs. So, of course, he loses money at the beginning, but he does it because he knows that he's the only one who can sustain this practice. So the competitors, one after the other, will have to leave the market, and then he will recoup, because he will put prices above the competitive level. So here it's much more subtle practice, and in particular when it comes to damage to consumers, you have to consider that in the first period consumers are benefiting from this practice because prices are much lower than the competitive level. But then the problem is that after the dominant operator gets rid of the competitors and can price as much as he wants. So in all this, I just would like to give you a simple understanding of what a judge, also a competition authority or a competition prosecutor, does in such a case, which is, as you will obviously say, not very difficult, not very different from what the judge does in other cases. So the judge establishes the existence of an infringement, evaluates the evidence, draws the consequence to establish which are the consequences, and quantifies damages. Let's see briefly these different moments of these different steps of analysis. First of all, when the judge has to establish a possible infringement, as I said, has to consider that in the two basic provisions, and of course in all the implementing provisions even more, there are a lot of economic concepts. So first of all, a judge has to decide if, in this case, what is acting is an undertaking, because an undertaking is somebody who's exercising an economic activity, but in the meaning of the treaty is not equal to a company, because a private person which operates on the market and has market power is an undertaking under European and national competition law. A very important notion is also the one of market definition and market power, because in order to understand which the effects of the practice are on the market, you have to understand what the market is, and to define the market, you have to follow a kind of simple economic analysis. And in particular, you have to understand which are the effects on competition, on workable or effective competition, as in the language of EU law. And this, in this case, only when you apply EU law, if this has effect on trade between member states, but conversely, if you apply national law, if this is has an effect on the national markets. And also, you have to get familiar with which are the typical instances of anti-competitive practices, which are practices which are listed both under Article 101 for cartels and under Article 102 for abuse of dominant position, which basically, I simplify here, are behavior which fix market conditions, so that they agree on purchase or selling prices, quantities, or other conditions. They restrict markets and share markets, or they discriminate or tie or bundle two products together in order to exploit the fact that one product is more important. Like we heard the example before of elevators, you can impose, if you are a dominant operator in the elevator market, you can impose to provide maintenance of elevators. So you say, okay, I sell you the elevator if you sign a contract of guarantee and maintenance with me. So an operator which is only providing maintenance of elevators is out of the market because he cannot maintain the most of products on the market. Then you have to evaluate the evidence, but this is something, I don't have anything to tell you or to teach you about that. This is what you do regularly. The only thing you have to take into consideration when you evaluate the competition practice is that the treaty distinguishes violation by object against violation by effect, in the sense that if a violation is considered more serious by competition law, you don't need to demonstrate its effects. Its effects are presumed. This is the case, for instance, of price-fixing cartel. If competitor, instead of competing, they raise the price, of course they damage the market and they at the detriment of consumers. Otherwise, so your analysis, the usual one, you analyze facts and evidence, you give them a legal qualification and you decide. However, if you have to consider the economic effects of a behavior, then you, in addition to consider facts and legal qualification, you have also to undergo a kind of economic effect-based analysis, and there's the need for in-depth economic analysis in depth. Then, third step, you establish the consequence of an infringement. This is quite obvious, depending on the fact that you're an administrative authority or administrative court, you deal with fines and remedies, or civil court, you deal with damages. A criminal court deals with, of course, criminal sanctions. Then you quantify the damage if you're called in a damage action. Again, this is a traditional civil law analysis. You have to understand if there's a violation of law, a damage, a causal relationship between the two, and to measure how much is the damage. In this case, it's important to consider that the distinction between object and effect of the practice is not important, because in any case, you need an in-depth analysis of the effect of the practice, because one thing is to say that the companies are guilty of a cartel and they are subject to a fine. Another thing to say that you claim that you had specific damage linked to that cartel. Then, unfortunately, you need this economic analysis that you didn't use to qualify the cartel. And this is very important when you have damage actions following a decision of a competition authority, because if it's, let's say, stick to the case of a cartel, it's a violation by object, so the competition authority or the European Commission will not have an in-depth analysis of the effect of this practice on the market and on the consumers. So the plaintiff and the judge will be confronted, and to a lesser extent the defendant, will be confronted to an analysis which is missing there, so and has to be performed in the case. So what is important is all this. Then it's the same you do in other cases, to find the counterfactual scenario, what is likely to have happened before, without the infringement. For instance, how prices would have evolved without the cartel, or would the fair price that the dominant operator should impose in certain circumstances. And this is a complex evaluation based on one hand economic data, economic facts, factors, which are normally called variables, which are the market share, cost, profits, prices, and on assumptions. So what is the method of the economic analysis, which is based on different methods and techniques, but I will come back on that in a minute. Now, let's just provide a few elements on how economics enter a law court and which is the peculiarity of a competition case. First of all, this is very trivial, very simple, but important to, when you speak about economics in court, you have to differentiate what is economic data and what is economic arguments, because data are facts, are evidence. So, for instance, what are the prices, what are the costs? This is direct evidence, so you are very familiar with that. You have to perform an evidence-based analysis. Are these facts true or false, likely or unlikely? I mean, prices, what's the evidence of prices? The official list of prices of the company, their records in the bookkeepings. They also have, let's say, under-the-table arrangements of or bookkeepings. You have this evidence and you decide if, in this case, these are the prices which are effectively applied, and so on. On the other hand, economic arguments is a different thing. It's more similar to circumstantial evidence. For instance, the likely effects of the behavior, on like the cartel, on prices. Here, of course, economists will have, probably if the case is complex, will have 10 different theories, which all are reasonable and explain a part of the story, but do they explain you all you need to know in order to adjudicate the case? And in this case, the analysis is not if these arguments and theories are true or false, like for the economic facts, but if the arguments are well-founded, and in this case, of course, you don't evaluate the calculation, but you evaluate the assumptions, because from different assumptions you get to different conclusions. So in this case, you have to understand if the assumptions are the ones you need in order to understand the effects. And in particular, if they are conclusive, if there is an alternative explanation of these facts. Because, for instance, you have, in the example I made, the plaintiff, let's say, so you look, there is a strange variation of prices during the period of the cartel, and they make an economic analysis. The economic analysis is sound, it's well-made, calculations are correct, but is this the only explanation? Then the defendant comes and says, look, but in the same period, the prices of cereals has increased, so this is an additional factor. You can have even more factor of that. You can even consider that in the same period there was a law imposing the milling companies to adapt their machines for security of workers, and this involved a big expense just in that period. So, of course, a sound economic analysis doesn't mean that it's enough for you to judge on the basis of that conclusion. Which are the main areas? These are just examples of the economic analysis you are confronted in the court. Well, of course, the first, the most simple, the most obvious one is market definition, because when you speak about competition law, you analyze something which has effect on the market. So the first let's say analysis you have to be familiar with is the definition of the product and the geographic market, and you find one of the first most common used acronyms, this SSNIP test, which simply, well, it means that a small significant non-transitory increase of price. Basically, it is a test, a hypothetical test, which considers what happens if the price of product increase to a certain extent, let's say 5%. Do the consumers buy another product? If this is the case, so there's, as economists say, cross-elasticity in demand between two products, then it means that two products are in the same market. And this is not obvious, because sometimes the market definition also, from the market definition, depends the definition of a dominant position. Let's say you can be dominant. The only importer or producer or wholesaler of apple in a certain territory but this is the only fruit you deal with. So if the market is the market of apples, you are a quasi-monopolist. But if the market is defined as the market of the fresh fruits, you're just one of the many players of the market. And how you understand whether the market is those of the apples alone or those of fresh fruits? You make an analysis of what happens if the price of apples increase of a small extent, like 5–10%. Do consumers buy pears, for instance? If this is the case, of course, pears and apples are in the same market. Then does also the price of the consume of oranges is influenced? Okay, if yes, you also have oranges in that market, and of course everything changed. And this is something which happens, for instance, the Commission has dealt with the fruit markets, arriving to the conclusion, for instance, that a very famous old case that bananas are not in the same market of fresh fruits because of their special characteristic. They are available all through the year, they are most suitable for old people and kids, and so on. So, of course, if you consider the main banana producers in the world are 2–3. Chiquita, Dole, and another one I don't remember. But if you consider the old players on the fruit market, there are more. So these companies probably won't be dominant on the overall fruit market, but they are dominant on the banana market. But this just to make you an example, and I don't have the time to go further in this, but I just mentioned which are the other aspects, like market power is the once you establish what's the market, is that company dominant on that market, and how you calculate the dominance? Is it enough that the company has 80% market share? Or you need, of course this is the highest the market share, the highest the likeliness, that the likelihood that the company has market power, but it's not all, because in some markets entry is very, very easy. So there are no barriers to entry, there are no licenses, you don't need licenses, you don't need big investments. So if this company, even if it has 80% increase a bit the price, maybe a lot of companies can enter from one day to another, so it might even not be dominant, and so on. And of course you have to understand the anti-competitive effects, as I explained. And this is the same for damages. You have different kind of analysis you have to make, and in particular, sometimes the analysis of damage, it changes according to the practice you are dealing with. For instance, in cartels, when you speak to damage to undertakings, in our example before, the bakeries, which complained about the cartel of the flour sellers, the mill companies, they have damage because prices are increased, but at the same time, bakeries increase the price they apply to, I don't know, supermarkets or to final consumers, which are their customers. So, of course, they recuperate this price, but at the same time, you have to consider that if they increase price, consumers will buy less bread, so in any case they lose, but they don't lose the whole increase of wholesale price, they lose something less. And according to the applicable law, you can take into account this passed on price or not. However, on the contrary, damage to consumers is relatively more simpler because it's the increased price of the product. On the contrary, as I briefly mentioned before, in a predatory pricing case, damage to competitors, it's relatively easier. Well, it's easier to quantify because you have to stick to costs and loss of profit. It's very complicated, but conceptually it's easier. But when you have to consider possible damage to consumers, you have to consider that the consumers at the beginning, they got an initial benefit because prices are lower than they should be in a competitive market. So prices increase only where this recoupment takes place, when the dominant operator, after having got rid of his competitors, he increases prices. And of course, finding out what a competitive price is very, very complex. And what tools, methods are normally used for economic analysis? In complex competition cases, often are used tools which are called quantitative tools, such as econometrics, that in the legal world is almost a bad word, because lawyers are not too familiar with this, and they feel lost when it comes to it. But at the end, in simple terms, this practice helps establishing the relationship between different economic factors that you would not understand immediately. And these are And of course they help identify the counterfactual scenario, what is like to have happened without the infringement. And they are useful in different levels of analysis to identify the behaviors, to understand the relationship between the behavior and the effects, and also to establish remedies, because when you establish remedies, you have to predict how the market could change after having applied that remedy. If you say to the dominant operator that his cost strategy, his price strategy should change because it's eliminating competitors illegally as it's doing, you also have to understand what the effect of this specific measure you impose will have in the market. And okay, very briefly, there's this very interesting break because we learned about a new, very interesting development also for me in Romanian competition law, because as you know, most of the European countries do not have criminal provisions for competition law, so this is very, very interesting to see how this is developing and which are the things at stake. Coming back to my trivial economy, as I would say, I was planning just at the end of my presentation to give a very simple example of how this economics tools can be used in a competition law case. This could be further developed in a proper case study during the training, but here at least I wanted to provide you with the first idea. So, why do we apply these economic theories? First of all, to understand what to find out, the so-called theory of harm, which is the story behind the violation of competition law. Then, of course, the analysis helps us in how to find it out, and I will provide a brief example of output of economic analysis, which I already put it forward at the beginning. And then, what is most interesting, and this is probably partial, an idea of what the judge can do in all this, which is the scope of the legal evaluation in with respect of the economic analysis. I will do this with a very simple explanatory table, and then trying and understanding how to judge this quantitative analysis results. First of all, the analysis, we use this analysis to find out a violation, and in particular, these quantitative tools are very useful to understand the relationship, the causal relationship between economic factors, which are not as clear as the correlation between other facts that you are used to deal with. For instance, in our case, what would the product's price, the flour, be without a cartel between the milling companies? The economy tells us how to find it out, and this is a the example I put forward at the beginning is very simple. There are much more elements which normally are taken into account, but this is just to make you understand what we are talking about. You can, for instance, a basic economic quantitative analysis involves comparing prices before and after the cartel, taking account of the so-called variable of interest, so the thing you are looking for. This is the price of the main product, flour, and then the so-called influence variables. I mean, if there are other variables which can affect it and change the relation between the cartel and the main object of your inquiry. I just, as I said, mentioned the prices of raw materials, cereals, but there could be much more variables, as I said. I mean, the whole economy in those years of the cartel might have been affected by increase of prices, new laws obliging producers to increase their labor standards could have also increased the cost and then the price of raw materials. So you can apply this in a more, of course, more developed way. But this is just to give an idea. No? You have an analysis in different steps. You have the first hypothesis, which is put forward by the plaintiff, by the competition authority, by the prosecutor according to the case. And this is the first graph here. No? It's what is called a simple interpolation. You have the prices before the cartel, you have the prices after the cartel, and of course you have the prices during the cartel. But when you represent it through mathematical calculation put in a graph, you see that during the cartel the prices are a bit particularly high. And so you can suppose, the hypothesis is that the price between the price during the cartel would develop somehow according to an average and draw this dotted line, which is the expected price of the cartel. But at the same time, the second element of evidence tells you that there is also a correlation between price of flour and price of cereals. So you have to take account of the correlation. And basically the third example, the third graph, which is called simple regression analysis, but this is not important to get into the details of these things, it simply puts together the two things, puts together the price of during the cartel and the expected competitive price, taking into account of one additional element, the cost of the raw material. If you take account also of other elements, the result would be different. So the key here is not to re-evaluate the calculations, to remake them up, because if they are properly done, they are reliable. It's just to understand, are these variables enough for you to take a decision? Is this all for you to understand the story behind? And that's where I come to this slide of what can the judge do when evaluating economic analysis. Well, first of all, and it's very key, and this is something you're very used to, determine the standard and the burden of proof under the applicable law. Because sometimes you can solve this based only with reference to the standard. For instance, if the plaintiff has not provided, in a civil damage case, if a plaintiff has provided elements which are contradictory, which are not enough, you can simply say, okay, this is not enough, I cannot condemn the other parts. Or if the plaintiff has brought elements which are enough according to the legal standards of evidence, and the defendant does not bring as many elements which are able to contradict this, then you can adjudge the case to the plaintiff. But in most of the cases it's much more complicated than that, so you will have to deal with complex economic analysis. And then what you can do is to verify the hypotheses and assumptions behind the mathematics, behind the calculation, when necessary with the help of an expert, but not in all cases. I mean, this verification is based normally on industry knowledge, so there might be an expert from the industry saying which are the elements which in practice affect that industry, or on the basis of experience, or sometimes on the basis of common sense. In Italy we used to use this Latin broker like Iudex Peritus Peritorum. The judge is the expert of the expert. The only thing is he has to understand what its action can be assessed. And sometimes what the judge has to do is very simple, otherwise it can be highly complicated, because where calculation can be left to the experts, but the judge has a very important role, I would say, improperly, before and after the economic analysis. Before, when he assessed the assumptions, because let's say quantitative analysis is, if it's properly done, it brings a result. Now, sometimes this result can be enough, sometimes cannot be enough. It depends how many assumptions you use. For instance, if you, to come back to the example before, you have a simple correlation between cartel and prices, but obviously you can assume that this is not enough, because prices depends also on other factors. You might maybe ask an expert in the industry saying how you normally fix price. So first of all, you consider the inputs, the raw material. So if you have any sense that prices in raw material might have been changed, you know for sure that the assumptions are not correct, even if that correlation is correct, because it simply says how much the two elements have been developed together. And in other times, it's the analysis itself which tells you its weakness, because a quantitative analysis, if it's properly made, it tells you which is the percentage of confidence. To put it in simple terms, it says, okay, this is true with a confidence of 80% or 90%. It means that in 10% of cases, this could also not be true. So in this case, the judge has to know if this 90% of confidence is enough to adjudicate in the case to the party which is providing the evidence or not. And this really depends on the legal standard, because if we are talking about a civil case, the standard is to, at least in the jurisdictions I know most, is to adjudicate the case to who provides the evidence of the which is most likely. I put it very, 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 very simply. But if you are in a criminal case, things are completely different. You have to prove guilt without any reasonable doubt. And then, of course, the standard of evidence is much higher. And even if you have a 10% or 5% uncertainty, that's not enough to put somebody in jail. It could be enough to adjudicate damage to a certain extent, but it's not certainly enough to put somebody in jail. So, of course, this is something it's only up to the judge. For instance, if you have another moment, the judge, of course, it's decisive, is after, is to interpret the result, because that's the example I put, interpreting the result. For instance, the judge can adjust, if the legal system allows, the results based on equity. For instance, you know, in a damage claim, that all the elements gives you a level of proof up to 90%, 95%. Well, the judge can say, to me this is sound. I'm truly convinced there has been a damage. There is this 10% uncertainty. Okay, I reduce the damage. I think the damage is 100. I reduce it of 10%. I give 90% of damage. Sometimes judges are allowed to do that on the basis of either law or equity, but of course this depends on the standard of proof applicable. Then, quickly through the last slides, this is just a very simplified example of where legal and economic analysis go together in a competition law case. Of course, there's a qualification of a case. This is a legal interpretation of the applicable law. You have a cartel if you have an agreement between competitors. In this case, for instance, aimed at sharing markets of customers. The competitors in this case, they're not directly fixed prices, which will be anti-competitive by object, so very simple, but it's a bit more complicated. They simply say, okay, I sell into this region or nation, you sell into the other region, or I sell to business clients, you sell to families. In this case, of course, the increase of price is a consequence. You have an intermediate step. No? You reduce the output, and then the price go up. So it's but till here is still a legal qualification. Is that a cartel? Yes, it's a cartel. Then you go to the economics to understand the implication of this behavior on the market. Reducing competition in order to raise price is a typical exploitative behavior, but here you need some to get familiar with the economic terms of the law. Then you have the evidence search or verification. This is a purely legal activity. You have data, which could be economic data, but there are quantities, prices, costs. You have to check companies' books, list of prices, cost of purchasers, and this is the same and even more with facts. No? A cartel is based on communication between members of the cartel. Sometimes it's very, very difficult. You might find evidence of meetings, of communication, the fact that people are calling the managers, the sales managers of companies from phone recording, are calling each other by chance just one day before the price change. That's the first strong evidence that they talk about the prices of the product. If this is enough or not, that it's a matter of your judgment. Then there's, when you really need to evaluate the effects of the practice, then you need more in-depth analysis, as it can be the quantitative analysis. For instance, the correlation, positive correlation between reduction of the output and prices in this case. So then you need an economic study, or at the contrary, the negative correlation between other factors and prices, so that you can understand that the prices have been changed by the cartel and not substantially by other factors. And this is an economic analysis, but I come back to what I said before. The judge still has to verify assumptions and then the results. And then, of course, the decision to fine or to attribute damage or to sanction people, to put them in jail, is purely legal. So concluding, the judge in quantitative analysis results, the analysis based on data and hypotheses and assumptions. Having said that, judges are constantly confronted with complex evidence and arguments, even sometimes to understand if somebody shooting has killed a person. Maybe you need a ballistic expertise which says if, considering the position of the gun and effect, it is possible that it has been dead people killing or another people. So you know how to deal with complex evidence, and competition law is not a particular exception in this case. Provided they know what competition law is based on. So it requires evaluation of facts, data and assumptions, and at the end it tells, as in other cases, it tells what is the likely effect of an anti-competitive practice. I may be abusing these Latin brocards, but in the Roman time they were saying it quod plerumque accidit, that which generally happens, the most probable outcome of an act, facts, event or cause. Of course, this is the standard of civil law, so in the damage case. This is not the standard of criminal law, when you have to sanction beyond any reasonable evidence, or at least this is the standard in jurisdictions I know. I'm not a criminal lawyer. So, briefly to conclude, because I've already abused probably of my time, yes, competition law is at the crossroads between law and economics, and there are some, the judge has to be familiar with some economic concepts and tools. Economics is in two aspects. In the first case is both in the law. So the two basic articles have this economic notion and concept which the judge has to get familiar with. And in particular, economics is in legal analysis, where it is important to distinguish between data, which is facts and requires a simple analysis of evidence, and arguments or tool, where a careful consideration of theory and assumptions is required. So, to me, economic in antitrust decision and private enforcement or other decisions, it's not new. It's in the end, it falls under the standard of proof of criminal and civil law. This is just important to know which are the basis of this analysis, both in the law and in the application of the law. And with this, I finished my presentation, and I thank you for your attention. And of course, I'm available for any kind of questions.
Mulțumim mult lui Fabio. E ultima dată când mai mă scuz și mulțumesc pentru întreaga colaborare.